Hi, everybody. I'm Diane Brady. I'm here with David Fish, who is Senior Litigation Counsel at Romano Law, which, among other things, specializes in employment law and also entertainment law, which is perfect, David, for talking about what's happening with Lizzo right now. I should mention you're in a case that can't be mentioned in Nashville. I take it you're in a hotel room right now. Is that right?
I am in a hotel room. Yes. Yes. This isn't my
Well,
normal digs.
this is not your normal digs, but what do you make of this case? This is three dancers that are suing the singer Lizzo over a hostile work environment. Is this quite common?
Employment cases actually make up a fair amount of the docket in both federal and state court. Um, is it common for large employers, well-known people to be sued? Yeah, it is. One of the things that plaintiffs and certainly plaintiffs' attorneys think about if they're going to bring a suit, beyond whether there's liability, and we could talk a little bit about the allegations of the complaint, is is there somebody to pay at the end of the day? You could be wronged, you could bring a lawsuit and be successful, but is there someone on the other side that's going to satisfy a judgment? Um, Clearly, here there are
Right.
defendants of the company and Lizzo individually. They could satisfy a judgment. So these are fairly common.
Well, I would think. I mean, let's talk about what's unique and what's common here. Because workplace, if whether you're a dancer or whether you're working in an office, a workplace is a workplace. Is that correct? Or is there anything uniquely different about this kind of entertainment workplace? These are dancers that are on tour with a singer that's a certain image. Does that factor into what constitutes hostility or a hostile environment?
Well, I mean, you point out which makes this particular case and cases like it interesting because they're very different types of workplaces. Say at the outset, there are certain rules that apply across the board. Sexual harassment or hostile environment, sexual harassment, which is being alleged here, is if you're subjected to unwelcome sexual conduct in any setting, that could be actionable. But
Yeah.
I think what you point at is important here, that working in a traditional office space, you are not exposed to the same things you are when you are a dancer on a world tour for a very, very famous artist who uses sexuality as part of her image and act. How do the expectations change? Like I said, certain things are always off limits, but being exposed to things that are arguably sexual in nature, there has to be an understanding you're going to see some of these things. Although the complaint kind of goes a little bit beyond,
It
but I
goes,
think what we
well, we should talk about the specific complaint, but before we do that, I think it's also interesting to note, I think of celebrities often would have very extensive contracts when you work with them, certainly around non-disclosure. There's certain things you can't put in a rider. Is there, like, for example, like there would be no contract that would protect a singer like Lizzo against these charges simply by virtue of people signing their rights away.
that's right. You can't have someone enter into a contract which allows you to evade your obligations and rights and your obligations under the law, or ask somebody else to give up rights, constitutional rights they may have. So, but what you say is important in that there are certain things you can waive or acknowledge. You know, I mean, there were allegations of the dancers being, and it's questionable the way it's drafted, whether they were forced to go to sex clubs and participate, or encouraged or shunned if they didn't participate. Um, you could say, I guess, in a waiver that you may attend certain establishments. Is that okay with you? But
You
again,
may be
people,
exposed to nudity, that sort of thing.
yeah,
But
yeah.